I'm going Contracts Plus. I'm reading real property issue writing outline in this recording, which is going to be exceedingly long. Not very enjoyable, I can tell you that. Especially because I've read a lot of real property lately, like yesterday. So this isn't going to be fun for me, but because it's really longer than it has to be. I'd love to be reading the criminal law, criminal procedure issue writing outline right now, or contracts, which I've probably done before. I'd love to be doing that, but I have at least 2 essays to write for class this upcoming week, so I figured I would get this one started. And I do think, just kind of looking at what I've read before, that there's
25 days before the exam,
possibility that I might have already read Contracts to Crim issue rating outlines. So just kind of following up on that concept right now.
Eagles. Is that talking about
yeah.
issue right?
It would be, neither of those are in my law playlist, but criminal has 92 videos. It doesn't look like Crim. I've read the essay writing outline in Crim, so at least not in Crim. And I think criminal procedure is in the Crim playlist, which I just made public. There were people lurking on my page, so I made that one private for the longest time. But what I'm doing with this set of videos is bigger than that, more important than that. So it's back in the public view since I realize I have 126 subscribers. Some of them must be people trying to pass the bar. Contracts, I'm just checking on that too. Contract law, there's 34 videos in here. There's a 20-minute long contracts issue spotting outline. Let's
probably only comfortably have 15 minutes to a half hour on this topic, which is essay writing approach for contracts and sales.
So you already did it for contracts. All right. Crim, we could do that right now, but we're going to do real property, and we'll get around to doing Crim, some other time. So, preliminary considerations and issues. Real property questions are straightforward. Primary problem of classification of the interest and the attendant characteristics of that interest. Your answer is driven by definitions, interrogatory or interrogatories. Here's some examples. What right, title, or interest in Blackacre, if any, did Andy initially convey to Beth, Chris, and himself? Discuss. What right, title, or interest in Blackacre, if any, is held by Andy, Chris, and Mom? Discuss. Example 2, Andrew has filed a lawsuit against Leo claiming he breached the provision of the lease stating landlord shall not operate a restaurant within 5 miles of the premises during the term of the lease. How is the court likely to rule on Andrew's claim? Discuss. Andrew has filed a lawsuit against Barbara claiming that she breached the provision of the lease stating tenant and his or her guest shall have the right to use lot 2 for parking. How is the court likely to rule on Andrew's claim? Discuss. Example 3. It's funny because they actually give you the year, the month and the year of when those interrogatories were asked, which the first one was July 2011, the second one February 2011. Example C, July 2008. What are the property interests of Betty and Ed, if any, in the condominium unit? Discuss what relief, if any, may Ed obtain on his claims against Betty for past due rent for her use of the condominium unit and for a share of the rent paid by the tenant. Discuss what relief, if any, may Betty obtain on her claim against Ed for contribution for the cost of maintaining the condominium unit. Discuss example D, on what theory could Larry reasonably assert a claim to recover rent from Tanya for March and April, and what defenses could Tanya reasonably assert against Larry's claim for rent? Discuss, that's from July of 2007. So the issue checklist, beginning with Roman numeral 1, classify and validate the interest. A, ownership interest. B, possessory interest. Is there a C? I can't even tell if there's a C. No, there's no C. There's a subpart 2, state the characteristics of the interest. And then there's a subpart 3, state any limitation to the interest. And subpart 4, any conveyancing issues. Subpart 5, remedies. So the outline of your essays would follow those headings. I'm going to probably say the exact same thing in this next outline titled Real Property Issues. So Roman numeral 1, classify the interest and ask if validly created. I think that's what I just said, right? Ownership interests is part A. Part B is non-possessory interests. Under ownership interests, there's 1 through 5, present possessory estates, including fee simple absolute, defeasible fees, and life estate. Part 2, there's the future interests of the grantor and the grantee. 3rd, concurrent estates, joint tenancy, tenancy in common. And 4th, landlord-tenant, non-freehold estates. And 5th, adverse possession. Non-possessory interests 1 through 6 is easement, license, profit, covenant running with the land, equitable servitude, lateral and subjacent support. State the characteristic of the interest. This is subpart 2. Attributes is part A, and B is rights and duties. Subpart 3, state any limitation to the interest. Subpart A is exceptions or termination. B is public land use. And subpart 4, conveyancing. A, contracts for the sale of land. B, deeds. C, delivery. D, title. E, recording. Next page. Pulling up the next page. F, mortgages, and then subpart 5 is remedies, broken into damages, restitution, and specific performance. So now we're going to do the exact same thing. Instead of calling out what the issues are for each of those sections, now we're going to read the rules. So this is where it's going to get boring. In present possessory interests, fee simple absolute is absolute ownership with indefinite duration. And this is subpart 1, possessory interest, estates, and land. And then A, present possessory interest, fee simple absolute, the absolute ownership with indefinite duration. To A and his heirs is an example. The characteristics is it's divisible, descendable, and alienable. Defeasible fees, the fee simple determinable, terminates upon happening of stated event, right? Event, and automatically reverts to the grantor. To A for so long as, or during, or until are the words that reserve or create a reversionary interest in the grantor. Characteristics are that this is divisible, descendable, and alienable, and the grantor retains the possibility of reverter. That's what that's called. For a fee simple subject to condition subsequent can be terminated by grantor upon happening misstated event. To A, upon the condition that, and these are examples, or provided that, or but if, or if it happens that. Those are all examples of the fee simple subject to condition subsequent, right? Which can be terminated by a grantor upon happening the stated event. And the characteristics are divisible, descendable, and alienable. The grantor retains a right of entry or termination. And C, fee simple subject to executory limitation, terminates upon happening of a stated event. Then passes to a third party. To A, but if stated event happens to B. Characteristics are that it's divisible, descendable, and alienable, and termination is automatic, and future interest is not reserved to the grantor this time. It's in a third party. I think they're also called remainderment. Life estates. This is part 3. So the first section was fee simple absolute, followed by defeasible fees, and then life estates, which are measured by the life of one or more persons, the life of the grantee. To A for life as an example, and the characteristics are A and B. Creates a reversion in the grantor or remainder or executory interest in the third party. Life tenant entitled to ordinary uses but cannot commit waste below. So we're going to talk about that in a later section. And there's also life estate per ultra V, which is another life estate, right, measured by the life of another person than the grantee, like another life of another person, not the grantee. So 2A for life of B is an example. The characteristics are the same as for the life estate. Waste, the examples of it are right here. There's affirmative or voluntary waste, which is the actual overt conduct that decreases the value of the estate. 2 is the permissive waste or neglect, failure to protect or preserve land. And 3rd is ameliorative waste, change that economically benefits the property. Future interest in grantor, possibility of reverter, follows a fee simple determinable, right of entry, power to terminate, follows a fee simple subject to condition subsequent. So these are the correlative future interests in the grantor, the possibility of reverter we talked about, the right of which follows the fee simple determinable, and the right of entry is the power to terminate following the fee simple subject to condition subsequent. Reversion, resulting interest when grantor transfers an estate lesser than the grantor had. Part 2 of this section is in grantee or third person, vested remainders is A, in which there's 3 sections under A: the vested remainder subject to complete defeasance, and the vested remainder subject to open. So just plain vested remainder is created in an ascertained person and not subject to a condition precedent, whereas the vested remainder subject to complete defeasance is the remainderment's interest could be cut short by a condition subsequent, and then the vested remainder subject to open the remainder's interest subject to diminution because additional unascertained persons can qualify as a class member. Part B with future interest in the grantee or third person. Part B is the contingent remainders. These are created in unascertained person or subject to condition precedent or both. The rule of destructibility of contingent remainders. Destroy contingent remainder because gap between preceding and succeeding interest caused by existence of condition precedent. Merger rule. Destroy contingent remainder when the person acquires all present and future interest except contingent remainder. Rule in Shelley's case, remainder to only grantees heirs of a life estate in grantee not recognized. Grantee takes in fee simple. And then the doctrine of worthy or title is the remainder in the grantor's heirs becomes a reversion in the grantor. And I was just reading this yesterday. I think I understand the doctrine of worthy or title, but the rule in Shelley's case is beyond me. Like, worthy or title, I feel as though if I said to A's heirs, like, that wouldn't work out because until A dies, A doesn't have heirs. So I think I understand that to be the doctrine of worthy or title. You strike that. It says here, remainder in grantor's heirs becomes reversion in grantor. So the effect of it would be that if I tried to, give to A's heirs, you struck that, I would just have a reversion. So I still have my stuff. Didn't go to anyone. But the rule in Shelley's case is a remainder to only grantees heirs of a life estate in grantee not recognized. In which case the grantee takes in fee simple. I wonder if that's like, I give Blackacre to A and her heirs to A for life and her heirs. Such as like a fee simple. I don't know what that means. So read that from another place. Executory interests, Part C, in future interest in the grantor third person. Shifting executory interest, third person's interest cuts short in interest in another person. And 2, springing executory interest, third person's interest cuts short in interest in the grantor or his heirs. So if it shifts, it's cutting short the interest in another person. If it springs, it cuts short an interest in the grantor or his heirs. Rule against perpetuities, wrap. No interest is good unless it must vest, if at all, within 21 years of a life and being at the time of the grant. There are 4 notes after the definition. 1 is the fertile octogenarian, presumption that a person is fertile no matter what their age is. And then the unborn widow, as a person's widow is not determined until death, so a disposition to the issue of the widow violates RAP. And class gifts and interests of any class member may vest too remotely, the whole class gift fails. And charities, gift from one charity to another will not violate RAP. Concurrent estates, so we're in Part C now. I think we're still in subpart 1 though. So concurrent estates, joint tenancy. A, creation requires 4 unities: time, title, interest, and possession, plus clear expression of right of survivorship. B, when one co-tenant dies, his or her interest automatically passes the surviving joint tenants. C, interest is transferable but not divisible or descendable. Termination, severance by inter vivo sale or conveyance, and partition voluntary, partition in kind, and for sale are some examples. Tenancy in common, A, B, and C. Each co-tenant owns an individual part with the right to possess the whole. Interest is descendable, divisible, and transferable, and no right to survivorship. And the presumption favors tenancy in common. Tenancy by the entirety. A, marital estate that can be created only between married persons who share a right of survivorship. B, special protections include creditors of one spouse cannot reach the tenancy, and a unilateral conveyance by one is invalid. Fourth, rights and duties of co-tenants. Possession. Each co-tenant has right to possess the whole, but no right to exclusive possession of any part. B, co-tenant in possession has right to certain profits from own use of the property. 1 and 2. 1 must share net from third-party rent, must share net from net profits from exploitation of the land. C, within rights and duties of co-tenants, is each co-tenant responsible for fair share of taxes and mortgage interest payments. D, co-tenant who repairs is entitled to contribution for any reasonably necessary repairs as long as she has given notice. And E, co-tenant has made improvements. The co-tenant who has made improvements has no affirmative right to contribution unless there is a partition. And lastly, the co-tenant must not commit waste. Landlord-tenant, this is subpart C, I'm guessing. Non-freehold estate is another way to refer to these leases. Types of leaseholds, there is a tenancy for years, periodic tenancy, tenancy at will, and tenancy at sufferance. So that's your holdover doctrine. Going back to A, tenancy for years, lease for a fixed determined period of time. Requires written lease, ends automatically at termination date, and notice is not required. Periodic tenancy is a lease that continues for successive periods until termination by proper notice of either party, created by express agreement, implication, or operation of law. And tenancy at will is a lease for no fixed period of duration and terminable at will of either landlord or tenant, requires express agreement. That lease can be terminated at any time. The tenant's duties. The tenant has a duty to repair. The tenant must maintain the premise and make ordinary repairs. 1, waste, see above. 2, destruction of premises without fault, no waste. Neither party must restore, but tenant has duty to pay rent in the event of a destruction of premises without fault. Statute or case law may give tenant option to terminate the lease. Fixtures, chattel that has been so affixed to the land that it is no longer personal property. A, fixtures pass with ownership. B, tenant may remove if it does not cause substantial harm to the premises. And B, duty to pay rent. I just every time I read this section, I think about the lady who basically asked me if she could replace my stand-up washer and dryer. And then when I took possession of the property back, there was no washer dryer there. Just never forget that. This section reminds me of it every single time. Duty to pay rent. 1, if the tenant breaches duty and is in possession, landlord can only evict through courts, continue relationship, and sue for rent due. If tenant is out of possession, landlord may treat the tenant's abandonment as a surrender, ignore the abandonment, and hold the tenant responsible for unpaid rent, or relet on breaching tenant's behalf and sue the tenant for the deficiency. Liability of third parties. Tenant liable even where landlord has expressly promised to make repairs. Landlord duties. Duty to deliver possession at the beginning of the term. Implied covenant of quiet enjoyment. Tenant entitled to quiet enjoyment without landlord interference. Actual eviction, landlord excludes tenant from entire premises and tenant does not have to pay rent. Partial eviction, landlord excludes tenant from part of leased premises and tenant does not have to pay rent. Constructive eviction, landlord's conduct causes premises to be uninhabitable. A, tenant must vacate within a reasonable time after giving landlord notice and time to repair. Tenant can terminate lease and sue for damages. Implied warranty of habitability. Residential premises must be fit for human habitation. 1, 2, 3, and 4. 1, tenant may vacate and terminate lease. Tenant may make reasonable repairs and deduct costs. Tenant may reduce or withhold rent, and tenant may remain in possession, pay rent, and seek damages. Retaliatory eviction. Landlord may not terminate lease or otherwise penalize a tenant for exercising his rights. Tort liability, common law, landlord has no duty to make premises safe. Modern law, the landlord is liable for common areas, latent defects, assumption of repairs, public use, or defects in short-term lease of furnished dwelling. And fourth, assignments and subleases. Tip: if there has been an assignment, then follow this issue up with a brief discussion of covenants that run with the land. For landlord to be able to enforce the covenants against the tenant and vice versa, he needs to show that the covenants run with the land from the assigner to the assignee or landlord 1 to landlord 2. Assignment, absent an express restriction in the lease, tenant transfers entire leasehold interest. 1, 2, and 3. Assignee stands in the shoes of the tenants in relationship with the landlord. That's privity of the state. Assignee and landlord liable to each other for covenants that run with the land. And third, assignor, original tenant, and landlord are no longer in privity of the state but remain in privity of contract. Landlord and assigner will be secondarily liable to each other. Sublease, absent an express restriction in the lease, the tenant transfers less than their entire leasehold interest. The sublessee and landlord are not in privity of the state or contract. The sublessor, the original tenant, and landlord remain in privity. Sublessee pays rent to sublessor, and landlord may terminate main lease for non-payment of rent. Adverse possession. If owner does not within statutory period take action to eject possessor who claims adversely to owner, title vests in possessor. There's 5 points to remember. Typically in 2 scenarios, squatter and boundaries. I don't recall reading a note on that before. Okay, but what they are meaning to say is that's when you recognize this is an issue. The requirements of adverse possession is continuous, open, notorious, actual, and exclusive and hostile. So continuous means uninterrupted for the statutory period. Open and notorious means visible occupation of the land to afford true owner notice and use. Notice that the property is being adversely possessed, and the person in possession is using the land as the owner would use the land. Actual is an actual physical entry onto the premises. It actually doesn't have to be exclusive, which is why exclusive isn't written here, but that's like an element. I don't really know why they keep saying like it doesn't have to be exclusive. Like probably you're going to discuss that element anyway. Hostile is entry without the owner's permission. Possessor's subjective state of mind as it relates to the hostility is irrelevant, and tacking is permitted if there is privity, which I think is why they're saying that exclusivity doesn't matter. Is because like Goldilocks, right? I think it's Goldilocks. Goldie finds cabin in the woods, starts living there, and then like Prince Charming or whoever comes, starts living with her, and then she dies halfway through the statutory period, but like he continues to possess. They can tack together the period that she lived there, he lived there, and she lived there, and he lived there to obtain adverse possession. So that's what tacking permitted if there is privity means. And disabilities toll the statutory period required for adverse possession. It will not begin to run if the true owner was under some disability to sue when the cause of action first accrued, which is infancy, insanity, and imprisonment. For example, when Goldilocks came upon the cabin in the woods, at that very moment, the true owner was an infant. In the essay that I took for Applebaum. Rest in peace. So, non-possessory interests or servitudes is the next large section that we're going to read, for starting with easement. Grant of non-possessory interest that entitles the holder to use or enjoyment of another's land. The types are affirmative and negative. Easement appurtenant, it benefits the holder in his physical use or enjoyment of another tract of land. The dominant tenement is the estate benefited by the tenement. The servient tenement is the estate subject to the easement's rights. And then there's an easement in gross. The holder acquires right to use the servient tenement independent of possession to another tract of land. And when they say another tract of land, they're talking about like adjacent lands. Creation. Prescription is COA. COAH is the mnemonic. I think here. Because I just read a different one recently. So prescription is one, implication is another. Necessity and grant. So what do they call that? They said COA, but ping. I don't know what. Okay. I got the mnemonic for creating an easement is ping. Prescription, implication, necessity, and grant. That's ping. But for prescription, the element of prescription is COA, which is continuous, open and notorious, actual and hostile, just like it was for adverse possession. What is implication? For easement implied from prior or existing use. Easement implied from prior or existing use if apparent at the time of the division and use is reasonably necessary to the dominant tenement's use and enjoyment. C, necessity. The landowner conveys a portion of the land which is landlocked except over a part of the grantor's remaining land. 1, reasonable necessity for majority of states, and 2, strict necessity for minority of states. And D, grant requires a deed of easement in writing signed by holder of servient tenement. Scope of easement is determined by terms or conditions that created the easement. And termination of an easement is end cramp. Estoppel, necessity, and destruction. Cramp is the condemnation, release, abandonment, merger, and prescription. So to define what those things mean, by estoppel, termination of an easement by estoppel, the servient owner materially changes position in reasonable reliance on easement holder's assurance that easement will no longer be enforced. necessity, easements by necessity end when the necessity ends, unless created by an express grant. Destruction of servient land unless willful, condemnation, which is of the servient estate by eminent domain. And then better start winding up here. Release, writing given by an easement holder to servient holder. Abandonment holder demonstrates by physical actions in intent to permanently cease use. And merger, titles to easement and servient tenement vested in the same person. Does it say person? Prescription, adverse, continuous, interruption, or use for a prescription period. And license, mere privilege to enter another's land for a narrow purpose. Statute of frauds does not apply. Revocable unless estoppel applies. Profit holder may enter the servient tenement and take mineral, soil, or other resource akin to easements. Covenant, written promise, a contractual limitation to do or not do something related to the land. Types of covenants include affirmative and negative. The burden and benefit run with the land. For the burden to run, there needs to be which and v, right? Which is a writing, intent, touch and concern, horizontal and vertical privity. Writing is the original promise has to be in writing. The intent of the original parties must have been to bind successors. Touch and concern means that the covenant must relate to the use and enjoyment of the land. Horizontal and vertical privity, what that means for horizontal is the original covenanting parties were in a relationship independent of the covenant, and the vertical privity means that non-hostile connection between the promisor and successor established by contract, blood relation, or device. And notice is, I always don't understand why they put it last. Notice is actual inquiry or record notice. It's like the fifth element, but really should be the first. So that mnemonic ends up being witch envy. So I envy the witch who has a burden on my property. And for the benefit to run, you need WITC and VP, which is writing, intent, touch and concern, vertical privity. So it's a little less than what I just said. And then termination of a real covenant is a written release, merger of benefited and burdened estates, condemnation of the burdened property. And the remedy is money damages. Real covenants may be remedied by money damages. Whereas equitable servitudes are like essentially the exact same thing as real covenants, but there's no money damages available, which is why they're called equitable servitudes, is because they are represented as a promise that equity will enforce against the successor of burdened land who has notice. Meaning that the only way to recover in a dispute about an equitable servitude is in a court of equity. And in all other respects, it should be exactly the same as real covenants that I just discussed. So this will sound familiar. Creation requires a writing, intent, touch and concern, and notice. The remedy, like I said, was an injunction or equitable remedy. Implied equitable servitude or common scheme doctrine. Original deeds contain common restriction, but subsequent deeds are silent on like the common scheme or like neighborhood plan. Reciprocal negative servitude is something that proceeds from that, which is that a divider has a general scheme of residential development, including the defender's lot and notice, meaning like that is on record. Their subdivision. Oh my God, what is the name for that? You'll know in the MBE, they use it a lot. So if that's filed in the public records, then everyone's on notice to it. And you can be on inquiry notice to it if every single house in the neighborhood looks like, or it all is either the same design or the same type of use. You should be put on notice that there's some restrictions, development or building restrictions. Support, lateral support, and subjacent support. Lateral support, A and B, support of land in natural state, and support of land with buildings. So in natural state, I just have dash strict liability here, whereas support of land with buildings is strict liability if would have collapsed in natural state, otherwise negligence. So what they're saying is how to recover if like someone interferes with the right to land to be in its natural state. Some adjacent support is underground occupant must support surface and buildings existing on date subjacent estate was created. Liability for subsequently erected buildings requires negligence. Limitation. What does that say? Subpart 3, limitations, eminent domain. Fifth Amendment, power to take private property for public use for just compensation. So I think it's like no private property may be taken for public use without just compensation. I think that's how it reads. Takings. A, explicit is a government condemnation. B, implicit or regulatory is a private claim that the government regulation has an effect of the taking. 1, 2, and 3 examples. 1, categorical taking of all economic value. 2, reasonable return test. No taking if owner left with reasonable return on investment. And 3, diminution in value test. Taking if no reasonable return on investment. And just compensation. If the owner succeeds with the implicit taking claim, government must either compensate the owner or terminate the regulation and pay damages. You have zoning as part B in this section. The state's power to reasonably control land use for health, safety, or welfare. Variance is permission to depart from zoning. Area variance requires undue hardship, and that variance will not diminish property values. Use variance requires special circumstances. 2, non-conforming use cannot be eliminated at once unless just compensation. Conveyancing, land sale contracts, validity, statute of frauds, A and B, essential terms in writing, description of property, parties, price, and manner of payment is what's necessary, right, to meet the statute of frauds for a land sale contract, right? Reading that again, description of property, parties, price, and manner of payment. I feel like I'll finally remember this. Equitable conversion. Once contract signed, equity regards buyer as owner and risk of loss placed on buyer. Marketable title. Every contract contains implied covenant that seller will provide marketable title at closing. There's A through E in this section. A, defects in record chain of title. Title may be unmarketable because of defect in chain of title. B, adverse possession. Title acquired by adverse possession is unmarketable. C, future interests held by unborn or unascertained persons are unmarketable. D, encumbrances, mortgages, liens, easements, restrictive covenants render title unmarketable unless the buyer waives. And E, zoning restrictions, existing violation of zoning ordinance renders the title unenforceable or unmarketable. And seller's liabilities for defective property. A, warranty of fitness or quality. B, liability for defects. So for fitness or quality, none except sale of new house. Okay, so that's the warranty of fitness or quality is only going to arise in like a builder is selling a house they just built. This isn't like a reseller. Liability for defects. A seller can be liable for defects on theories of misrepresentation, active concealment, and failure to disclose. Deeds, formalities, delivery, and acceptance by grantee is required. The formalities, deed formalities are a writing signed by the grantor which reasonably identifies the parties in the land. And for delivery, the grantor's intention to make the deed presently effective, even if possession is postponed, and delivery is satisfied by manual delivery, notarized acknowledgement by grantor, recording, or anything else showing grantor's intent. Covenants of title and estoppel by deed. Quitclaim deed conveys no covenants. General warranty deed warrants against all defects. The present covenants are the covenant of cession. Grantor has the estate he purports to convey, the covenant of right to convey. Grantor has authority to make the grant. Third, covenant against encumbrances. Grantor warrants there are no servitudes or mortgages. Future covenants, covenant for quiet enjoyment. Grantor promises grantee will not be disturbed by a third party. And covenant of warranty, grantor agrees to defend and compensate grantee against claim of superior title. And third, covenant for further assurances, grantee agrees to act reasonably to perfect the title. And three, special warranty deed. 4, statutory special warranty deed. And 5, estoppel by deed. Subsequent acquisition of property by the grantor inures to benefit grantee except against bona fide purchaser. Recording. The statutes include notice, and race. So race is whoever records first is the owner. Race notice is subsequent bona fide purchaser is protected only if he records before the prior grantee. And notice means subsequent bona fide purchaser prevails over prior grantee who fails to record. And what's a bona fide purchaser? It's a purchaser without notice. Actual notice means that knowledge was gained from any source. Constructive notice or record notice. The recorded conveyances in the chain of title can be found, and inquiry notice is required to make reasonable inquiry and charge with knowledge of whatever that inquiry would have revealed. Mortgages, conveyance of security interest in land intended by parties to be collateral for repayment of monetary obligations. On default, lender can realize on mortgaged real estate by foreclosure. Hopefully that's getting towards the end. Yes. So last page now is parties, mortgage or debtor or note maker. Mortgagee is the lender. Redemption in equity or statutory in equity. It's at any time prior to foreclosure sale, mortgager can redeem the property by paying the amount due. Statutory, half the states allow redemption for a period after foreclosure sale. And priorities. A, priority is usually determined by chronological time it was placed on the property. 1, foreclosure does not destroy senior interest. 2, foreclosure generally destroys all junior interest unless junior interest holder is not included in the foreclosure action. Modification of priority by operation of recording statute. If prior mortgage E fails to record, subordination agreement between senior and junior mortgage E. Never forget, like, actually working with these in a bank. And the banks amongst each other actually, fax these to the other banks and get them endorsed. Third, purchase money mortgage. Mortgage given to secure loan that enables the debtor to acquire encumbered land gives mortgage super priority. Fourth, modification of senior mortgage. And fifth, optional future advances by mortgagee with notice of junior lien. C, proceeds of sale applied first to expenses of sales, attorney's fees, and court costs, then to pay principal and accrued interest on foreclosed loan, next to pay off any junior interest in order of priority, and finally to the mortgagor. Deficiency judgment, if proceeds are insufficient to satisfy mortgage debt, mortgagee retains personal cause of action against mortgagor for deficiency unless there's an anti-deficiency statute. Which has got to be a statute. So if they're saying common laws, that's going to mean that deficiency is recoverable. That's all there's really to say about that. There needs to be an anti-deficiency statute. Lastly, there's remedies, which is damages, restitution, and specific performance. So that's going to be how to write essays about real property. Put that to practice.